Hello and welcome to our series of video tutorials on Community Scheme Ombuds Service adjudications. The subject of this video is the adjudication of the dispute between Regina Lamoral, the applicant, and the Leisure Bay body corporate as represented by the trustees, as well as an owner within the scheme, Mr. Grant Eglin, and the managing agents. The application for dispute resolution relates to the behaviour of a cat being kept as a pet within the scheme by the owner, Mr. Eglin, and the trustees' failure to enforce the relevant conduct rules of the scheme. The applicant, during the course of the adjudication, raised the following points. The conduct rules of the body corporate provides that an owner of any pet kept within the scheme must ensure that the animal does not cause a nuisance and that the pets are not allowed in certain areas of common property, including the pool area. The cat, owned by the chairperson of the trustees, is allowed to roam the common property, including the pool area, and enter sections owned by other members of the body corporate, many of which are used for short-term letting. The trustees do not enforce the conduct rules of the body corporate or address the various complaints made. In argument, the respondent raised the following point. Various reasonable attempts have been made to address the complaints made by various owners and residents within the scheme, and warning letters have been issued to the owner of the cat. In determination of this dispute, the adjudicator looked at the term nuisance, and in its interpretation found that the behaviour of the cat, objectively seen, constitutes a nuisance and amounts to a transgression of the conduct rules of the body corporate. The adjudicator found that despite the fact that cats are likely by nature to roam and that the scheme is seen as pet-friendly, does not detract from the fact that other owners cannot be expected to simply tolerate the behaviour, and that weighing up of the rights of other owners, the complaints deserve protection. The adjudicator raised the question as to whether the trustees, as represented by the managing agent, did all things reasonably possible for the enforcement of the rules. In this regard, the adjudicator raised the consideration that in the absence of specific rules of remedial or punitive action in the case of rule contraventions, a determination must be made of what is considered to be reasonable, as well as what can be expected of trustees. In this regard, the adjudicator provided the minimum action to be the investigation of the complaints made, a decision as to whether the rules have been contravened or not, a decision as to the appropriate remedial action, and the issuing of a warning to the transgressing owner, unless the contravention is urgent, in which case a warning is not necessary. The adjudicator found that the warning letters issued by the trustees were not appropriate, as they did not refer to the correct conduct rule breached and did not provide the potential action that would be taken by the trustees should the rules be further disregarded. In light of these considerations, the adjudicator made the following order: that there was disregard or disobedience of the relevant conduct rule of the body corporate by the owner of the pet, and as such the trustees must issue an appropriately worded warning letter to the owner, providing that in the case of any transgression of the relevant conduct rule within a period of 6 months from the date of the warning letter, the trustees will order the removal of the cat, which removal is to take place within a further month. A cost order was made against the body corporate in this regard. I hope you enjoyed this video. Until next time, goodbye.